Ready, sir.
You're gonna have Ashley Haas as the attorney or Ms. Pollard?
It'll be me, Judge Ashley Haas.
An attorney for defense, Patty?
On Ms. Baird is Oscar Hernandez.
No, I'm looking at Lerma right now. MTEAG,
Yes, sir. Attorney is James Hunt.
James Hunt, Your Honor.
what's gonna be the plea?
Plea of no contest.
On the MTEAG.
Plea of true and terminate.
And what is the violation that is being pled to?
I guess state's choice.
Pardon me?
I guess state's choice.
Well, I don't do the choosing of which one she pleads to. You and your client do.
Actually, do you have a preference?
I'm not sure I have a copy of the motion.
I don't have a copy in front of me either.
Okay, so on this one, Your Honor, I didn't have it. I guess I don't have the updated docket. I didn't even know this was an add-on. I just sent it to you, Ms. Haas. Or do I need to send it to Ms. Reed? The court summary. It's violations, condition number 1, 2, 14, and 24.
We're pleading to the number 1 anyway, so we could.
And what is number 1? What does it say? Somebody tell me.
Committed the offense of DWI with BAC over 1.5.
Hold on, Your Honor, I'm sorry.
BAC 0.15?
Yes.
That was the original charge, Your Honor. He ended up pleading to obstruction.
Whoa. So, all right. She's gonna plead true to what? Somebody tell me. I have to type
Your
it in.
Honor, there's a number 1, on or about the 23rd date of December 2020 in Bexar County, Texas. The defendant, Jesse Alejandro Lerma, committed the offense of driving while intoxicated in violation of condition number 1. There is a violation condition number 2, on or about the 24th day of November 2020 in Bexar County, Texas. The defendant, Jesse Alejandro Lerma, then and there failed to submit to drug testing as directed by the court supervision officer in violation of condition number 2. There is a violation condition number 14, on or about the 24th day of December 2020 in Bexar County, Texas. The defendant, Jesse Alejandro Lerma, did then and there fail to complete 48 hours of community service restitution in violation condition number 14, and violation condition number 24. In Bexar County, Texas, the defendant, Jesse Alejandro Lerma, failed to comply with the rules and regulations for zero tolerance in violation of condition number 20.
All right, now, having read all that to me, I'll ask one more time. Which one is he pleading to?
Your Honor, the state, and if the defense is in agreement, he can just plead true to number 1, which is the allegation of the new offense, which he's pleading on today.
Which is
We're fine with that.
That on the 23rd of December 20,
Yes, Your Honor.
Yes, Your Honor.
defendant committed a DWI with a blood alcohol content 0.15 or higher. Is that correct? Hello?
Yes, Your Honor.
Yes, Your Honor.
Court finds true. As noted. Okay, entering finding of guilt. Well, he was not on, okay, he was on the deferred, right?
Correct, Your Honor.
All right, so we'll enter a finding of guilt. We'll alter and amend. What are we gonna do? What sentence outright? Hello?
Judge, do you want me to go on the record?
Actually, I'm trying to get this down on the document, then we can go on the record.
Okay,
So we're not gonna alter or amend. We're just gonna find that he committed the violation.
I believe this one would be terminate unsatisfactorily.
Yes, Your Honor.
Enter a finding of guilt. Then terminate unsatisfactory.
Yes, Your Honor.
And that's it. Nothing by fine, sentence, nada.
Correct, Your Honor.
Okay, I have completed the paperwork, so saying. All right. Mr. Lerma,
Yes, sir.
we have two cases, so what's gonna happen to the second one, the 652-584?
Probation, Your Honor.
So it's a separate plea on that one?
It is.
Okay,
And that'll be a plea of no contest, Mr. Lerma.
Mr. Lerma, would you please raise your right hand?
Yes, sir.
You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
And that is, go ahead and put your hand down. I'm referring to two cases, 581046, which is a motion to enter adjudication of guilt, and 652-684, which is a charge of DWI with a blood alcohol content of 0.15 or higher. Is this what was originally done or charged on 581046? Which he was on obstruction?
I'm not aware of the original charge. Lord.
On this one, on the 581046, Your Honor, yes, it was on deferred adjudication for obstruction of highway passageway.
All right, and now we, in addition to that, we're now looking at 652-684, which is a separate pleading for DWI with a blood alcohol content of 0.15 or higher. Is
Yes,
that
Your Honor.
correct?
Yes, Your
All
Honor.
right, then I have to take those separately. On 581046, Mr. Lerma, you were placed
Sir.
on a deferred adjudication, apparently. On what date, Ms. Luna?
Your Honor, he was placed on deferred adjudication on July 18, 2019. And
Right.
it was until January 17th of 2021.
All right, now, since that time, you have had a motion to enter adjudication of guilt filed against you. Do you understand what the proceedings are? Mr. Lerma,
Yes, sir. Yes, sir.
all right. Now, that's on case 581046. I need to explain several things to you. First of all, when you first entered that plea on that case, you were informed that you had a right to remain silent. You still have that right. You do not have to, you cannot be compelled to make a statement. You cannot be compelled to answer questions. You don't have to submit written paperwork. You understand you have that right.
Yes, sir.
When you originally entered the plea, you were told that you did not have a right to appeal. you still do not have a right to appeal the original plea that you made in this case. But you have a limited right to appeal, and that is that you can appeal this particular proceeding and the results of this proceeding. Do you understand you have that right?
Yes, sir.
All right. Now, the state has alleged several violations on your part. You heard them read earlier. Did you hear them and understand what they were charging you with?
Yes, sir.
It's my understanding that is your intention to plead true, admitting that you committed the DWI with a blood alcohol content of 0.15 or higher. Counsel, is that the case on 652-684?
Yes, Your Honor.
Okay, so you are pleading true to that, is that correct?
Actually, Judge, on the new case, they're going to abandon the enhancement. So it'll be just a regular DWI first.
All right, but didn't we just finish reciting and I put on the record that he had committed a DWI with a blood alcohol content of 0.1 high on December 23rd?
I apologize, Your Honor.
I'm asking, I want the record to reflect correctly what's going on.
I do believe so.
All right, so Mr. Lerma,
Yes, sir.
to the charge that you violated the conditions of deferred adjudication, that is obstruction of passageway, highway, or waterway, in that you committed a DWI with a blood alcohol content of 0.15 or higher. How do you plead, true or not true?
True, Your Honor.
All right, on a plea of true, then I have the authority to enter a finding of or a conviction on the charge of obstruction of a passageway. Do you understand that?
Yes, sir.
Did anyone threaten you, intimidate you, or promise you anything other than the plea bargain that you've entered in exchange for your pleading true?
No, sir.
All right, then I find that it is true. As a result, I enter a finding or a final finding of guilt on the charge of obstruction of a passageway, highway, waterway.
Yes, sir.
As a result, the sentence will be, in exchange for that plea, the court approves the agreement, and that is that you are terminated unsatisfactory from the case number 581046, obstruction of a highway, deferred adjudication. Now, on case number 652-684, you're charged with DWI with a blood alcohol content of 0.15 or higher. Is there a plea bargain on that matter, Mr. Hunt?
Yes, there is, Your Honor.
And tell me essentially what that is going to be.
The state or myself?
Either one of you, I need to hear it.
Your Honor, it's going to be, so the state will make a motion to abandon the extreme intoxication enhancement and proceed on a DWI first. And then the agreement is for 180 days, probated for 14 months. Fine of $600 plus court costs, 48 hours community service, DWI intervention program, DWI victim impact panel live, submit to a TAP evaluation and follow all recommendations, and an ignition interlock for half the term.
That is our agreement, Your Honor. And I would ask the court to amend the pleadings. I believe I checked that it was a Class A, and it is a class, it's a first DWI now.
All right. First of all, on the state's motion to reduce from DWI with blood alcohol content of 0.15 or higher, reducing it to a DWI first. There is no objection, I heard.
No, Your Honor.
There being no objection, the court grants you the motion to reduce it to DWI first, or Class B misdemeanor. To that charge, Mr. Ledma, how do you plead?
Mr. Lerma, it would be a plea of no contest. Mr. Lerma,
Just frozen.
I think he fell asleep with his eyes open.
I think he's logging back in now.
Your Honor, I had a question. Going back to the MTEAG. Was that one, I know it's term unset, but were we denying the MTR or withdrawing the MTR?
Neither one. He pled true. I find it true and I convicted him.
Okay,
Then as a punishment, I terminated him unsat. Well, actually, they're one and the same, aren't they? He was terminated unsat. I convicted him and then it was a termination unsat. All right. We're going to discontinue at this time on this particular defendant since we've lost him apparently on technical reasons. Mr. Hernandez, are you ready to proceed on Demi Moore? Excuse me, Demi Baird.
On both, Judge.
All right. I bet you wish. Ms. Baird.
Your Honor,
What is the charge on Ms. Baird? What are we doing?
Hello.
Hello.
Your Honor, we're taking a plea on the resisting 669-405. She has two other concurrent misdemeanors that are going to be TIC'd, and we're asking the court for a judgment satisfied 25 days, Bexar County Jail.
That's the agreement, Your Honor.
Resisting arrest.
That's the only one we're pleading on, Judge, yes.
All right, Ms. Baird, would you please raise your right hand? You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Thank you. You may put your hand down. Ms. Baird, before I proceed, I'm going to discuss with you on a record that's being made, official record by my court reporter, Ms. Kayleen Rivera. You have a right to remain silent. That means you do not have to say anything at all. You don't have to answer questions. You don't have to submit written paperwork that has your signature, especially papers that admit or confess to wrongdoing. You understand you have that right.
Yes, Your Honor.
Yes, Your Honor. Sorry, I had it on mute.
And incidentally, this is cases number 669-405, 669-406, and 407. I understand there's a plea agreement. 2 of them will be taken in consideration. On each of these cases, you have the right to remain silent. You also have the right to demand a jury trial on each case. That means that you and your attorney and the state's attorneys could select 6 people from a jury panel of disinterested citizens who could hear the entire trial for each case and decide whether you're not guilty or whether you've been proven guilty beyond reasonable doubt for each case. That's called the right to a jury trial. Do you understand you have a right to each one, each of the 3 cases?
Yes, Your Honor.
You also have the right to confront witnesses. If you went to trial, the state would have to present testimony to witnesses. And on each case, each witness, you'd have the right to cross-examine, question, or challenge that witness. It's called the right to confront witnesses. Do you understand you have that right?
Yes, Your Honor.
You also have the right to appeal on any and all cases. That means that you and your attorney or individually, you could demand a higher court review the official record of the proceeding and the evidence or whatever legal challenge you wanted to make. You'd have to be careful on right of appeal because it is very technical. You need to know how to use the forms and the substance of the appeal. And you have time limitations among other matters that you have to deal with, but you have the right to appeal. Do you understand you have that right?
Yes, Your Honor.
Ultimately, you also have the right to demand that this proceeding be held in open public courtroom. Because of the COVID pandemic, we are not doing that. But in order to proceed, you must agree to or consent to video conferencing on any or all cases that you do. Do you understand you have the right to demand a public open courtroom?
Yes, Your Honor.
All right. Now, in order to proceed, you reviewed some legal documents with your attorney and then you signed them. Did you have the help and counsel of your attorney in reviewing the legal documents involved in this case?
Yes, Your Honor.
And did you understand the documents that you signed?
Yes, Your Honor.
Did you have any questions, ma'am, that are not answered?
No, Your Honor.
All right. Now, the first one you saw was the one that's consent to video conference. Are you aware that you did in fact consent to video conferencing in this case?
Yes.
All right. Mr. Hernandez, did you assist and counsel your client in reviewing all the documents and paperwork and discovery in this case?
I have, Your Honor.
Did you in fact sign a document that affirms that the state did in fact comply with Article 39.14 Texas Code of Criminal Procedure in reference to full discovery?
Yes, Your Honor.
All right. Now, Ms. Baird, among the documents that you signed was one that is titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. It was extensive. It identifies you. It says what you were charged with, in this case, resisting arrest. It tells you that it's a Class A misdemeanor. Those papers also tell you that it lists 15 numbered portions and descriptions of rights and protections that you have. It includes the idea of a right to a jury trial, the right to remain silent, the right to confront witnesses. All those things are repeated in there. Are you aware of the document I'm talking about?
Yes, Your Honor.
Do you recall that you signed the document and that it also told you that whatever deal you made with the state, I am not bound by it. As the judge, I have the authority and responsibility to say yes or no to your deal. You understand that?
Yes, Your Honor.
If I refuse your deal, or if I give you a punishment within the legal range, but greater than what you agreed to, in that case, the law would allow you to start all over again. Do you understand that?
Yes, Your Honor.
Do you have any questions about that document?
No, Your Honor.
All right. Then there's also the final document that we call the plea agreement. Did you review it with your attorney?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
All right. State, tell me what the plea agreement is, please.
Yes, Your Honor, it's gonna be 25 days in the Bear County Jail with credit
No,
for
no.
time.
What is her plea gonna be?
Oh, it's no contest.
A no contest plea to 669-405 resisting,
Yes, Your Honor, and we will take into consideration the other two cases.
right? And what is the fine gonna be?
The fine will be $1,000.
Court costs?
And court costs, credit for time served, time and money to run concurrent. And we would request that the judgment be satisfied.
All right. Based on your plea and the evidence, Ms. Bayard, I find you guilty. Did anyone threaten you, intimidate you, or promise you anything other than the plea bargain in exchange for your plea of no contest to the charge of resisting arrest?
No, Your Honor.
All right, I accept your plea. I find you guilty. What is the sentence, Ms. Haas?
25 days, Your Honor.
You are sentenced to 25 days, Bear County Jail. A fine of $1,000 plus court costs. Credit, you're granted credit for time served, time and money run concurrent. The court finds that you have satisfied the judgment in this particular matter, and you owe nothing further to the state or to this court on this particular charge. On cases numbers 669-406 and 669-407, the court, as part of this bargain, takes in consideration both cases and dismisses those two cases. Does she have any other wants or warrants or pending cases?
She has a pending matter that she's on bond for. It's in a different court with a different attorney judge.
Okay, but she does have a bond on that?
Yes, I looked it up and it shows the bond.
All right, so then apparently, Ms. Baird, you're gonna be released sometime today. It'll probably be late in the evening.
Thank you so much.
Stay out of trouble, young lady.
Yes.
All right. Back on the record on 652-684, the state of Texas versus Jesse Alejandro Lerma.
Yes,
Mr.
sir, I'm
Lerma.
here. Yes,
All
sir.
right.
I'm sorry, we're disconnected.
Yeah, I always laugh and tell people, you know, to really screw up, you need a computer. So that happens to all of us, including the court and even the prosecutors. This morning, we lost one for almost all day. In fact, I don't think we've seen her back today. But
Yes, sir. My Wi-Fi is strong. I was just kicked out somehow. I don't know what happened. My apologies, sir.
no problem. Don't worry about it. Okay, let's continue with your particular case. You are charged with DWI with a blood alcohol content of 0.15 or higher. Now, before we proceed, I need to discuss with you that you have rights and protections by Constitution and statute. The first right is the right to remain silent. That means that you cannot be compelled to make any kind of statement. You cannot be forced to answer questions. You cannot be forced to submit written documents that have your signature, especially any documents that admit or confess to wrongdoing. Do you understand you have that right?
Yes, sir.
You have the right to a jury trial. That means that you and your attorney and the state could select 6 jurors from a jury panel of disinterested citizens who would hear the entire trial and decide if you're not guilty or whether you've been proven guilty beyond a reasonable doubt. That's called the right to a jury trial. You understand that?
Yes, sir.
You have the right to confront witnesses. If you decided to go to trial, the state would be required to prove up whatever evidence they were going to submit. And at that point, you and your attorney could question, cross-examine, or challenge any witness who would testify in the trial. That's right. That's called the right to confront witnesses. Is that clear?
Yes, sir.
There's also a right called the right to appeal. After everything is concluded, the thing is over, including punishment, whatever, At that point, you and your attorney have a right to demand that a higher court review the official record in this matter. The official record being prepared by the court reporter by the name of Kayleen Rivera. That official record, you could have a higher court review it for whatever legal challenge you wanted to make. Now, in order to do that, you have to be mindful that there are legal technical matters, including the form and substance of the way you do it, and including time limitations, among other things. So it's not just a real simple thing to do, but that right exists. Do you understand that?
Yes, sir.
Furthermore, you have the right to demand that this proceeding be held in the open public courtroom. That is normally the way we do things, but because of the COVID pandemic, we've been doing it by alternate means, in this case, through the internet on what's called video conferencing. Do you understand you have the right to demand that this be done in a courtroom?
Yes, sir.
This also is a right that the state has. So both of you have that right. Now, in order to proceed, you and your attorney have reviewed documents, paperwork, and you have signed them. Are you aware of the documents that I'm referring to?
Yes, sir.
Did you have the help and legal counsel of your attorney?
Yes, sir.
Did you have any questions that were not answered concerning any of the paperwork that you signed?
No, sir.
All right. Now, the first document that you did sign, or that I'll ask you about, is the consent to video conference. You and the state both have consented to do this hearing by video conference. Did you
Yes, sir.
review that and sign it?
Yes, sir.
Mr. Hunt, did you assist your client in reviewing the documentation and discovery that's involved in this matter?
Yes, Your Honor.
Did he, in your opinion, knowingly sign the documents that are involved?
Yes, Your Honor.
Did you sign an affirmation saying that the state has complied with Article 39.14 Texas Code of Criminal Procedure in that they have provided full discovery?
Yes, Your Honor.
All right. Mr. Lerma, you have also
Yes, sir.
signed a document that's titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. That document includes identifying you. It says what you're actually going to enter a plea to, how you're going to plead. It breaks down, it has 15 numbered parts that describe different things involving and including your constitutional rights and protections, the right to a jury trial, confrontation of witnesses, the right to remain silent, all the rights. It reviews it in writing. It also tells you that the deal you've made with the state is not binding on me as a judge. As a judge, I have the authority and responsibility to say yes or no. I have to decide one or the other, yes or no, on your deal. I also have the right to and authority to determine your punishment within the range of punishment. And I can give you a punishment within the range, even if it's greater than what you agreed to. However, if I reject your deal, or if I give you a punishment that it's in any way greater than what you agreed to, then in that case, the law would allow you to start all over again. Did you see and understand that this document tells you that?
Yes, sir.
All right. Now, there is a plea agreement that has been reached. Is this going to be a probation, folks?
Yes,
Yes,
Your
Your
Honor.
Honor.
What kind of probation?
Regular probation.
Regular. All right. Mr. Lerma, let's be real clear,
Yes,
sir.
sir.
Probation is a written, legal, binding agreement between you and this court. And that agreement is, among other things, that the punishment, including jail, physical jail time, in particular, will be suspended so long as you live up to 100% of the conditions of supervision. If you live up to the conditions, you don't come back to this court on
Yes,
this
sir.
case. If you live up to the conditions, every bit of it, you don't come back to this court. You don't go to jail. If, on the other side, if you violate the conditions by failure or refusal, then the state may ask me to give you official notice, bring you in. And at that point, if the evidence, in my opinion, is sufficient, I can go ahead and put you in jail. Do you understand that?
Yes, sir.
Now, we just got through a few minutes ago seeing that you failed or refused to comply with the obstruction of a passageway deferred adjudication, which is very beneficial to you. You dumped that. You screwed the pooch on that one. Do you understand that in this case, you come up again and the evidence shows it, you're very likely to go to jail. Do you understand what I'm saying to you?
Yes, sir.
All right. Then to the charge of DWI first, how do you plead, sir?
Guilty, Your Honor.
How about no contest?
All right, a no contest plea in this court is considered a guilty plea and is sufficient to convict you. Do you understand that?
Yes, sir.
Did anyone threaten you, intimidate you, or promise you anything other than this plea, under this agreement, in exchange for a no contest plea on a DWI first?
No, sir.
All right. Based on your plea and the evidence, I find you guilty. I sentence you to 180 days, Bexar County Jail. Probated and suspended for 14 months. You're sentenced $600, you're fined $600 plus court costs. You will complete 48 hours of community service restitution. DWI intervention. The DWI Victim Impact Panel Live. You will have ignition and interlock monitor placed on your vehicle for a minimum of 7 months. You'll submit to a TAP evaluation and the recommendations. There's other points in there about, for one, you have to report to the offices of County Court of Law number 5 so that you can have your thumbprint placed on the documents in this case. Do you understand?
Yes, sir.
All right. What do you do to make a living, sir?
I do commercial refrigeration, sir.
Well, that's good business.
Yes, sir.
What do you
Going
earn?
on
Do you
6 to
have
7
children you
years.
support? You have any
I'm sorry?
children you support?
I have a baby on the way. Yes, sir.
Okay, is the only one?
Yes, sir. My first one.
All right. And so what do you earn on a monthly basis?
That's a good question. I would have to check into that, sir. Off the top of,
I'm listening.
can you hear me?
I'm hearing you now.
Okay, my headphones there. Off the top of my head, anywhere between 4,000 and 5,000, maybe something like that.
All right. Your supervisory fee will be $56 a month.
Yes, sir.
Also, I'm changing your fine. I am raising your fine to $850. Because I'm doing that, you have the right to say, hey, you gave me a greater punishment than I agreed to, and you can start all over again if you choose to.
No, sir, I'm fine with that.
All right, I would think so, because your income is much greater than a lot of people that come in here and get a $500 or $600 fine.
I understand, Your Honor.
All right. Now, You're gonna have a new baby.
Yes,
The
sir.
worst thing can happen in your life is for you to be drinking and driving and you wind up killing your own baby. You think it happens?
I understand, Your Honor.
Do you think that happens? It happens
I
all
would
the
hope
time.
not.
This week, there was a young 17-year-old that killed 3 people because he was drinking drunk. 3 people. And the poor souls weren't even from San Antonio. They were here for some kind of a musical event. And a 17-year-old was drunk and he went and killed him. Now, the only thing that would have been worse for him is they killed his own family. He didn't. He killed innocent strangers. The worst thing for you is to kill your own. You keep that in mind because you already screwed up twice, drinking and getting into court. I would highly suggest to you that you straighten this little business out because you're going to wind up doing a hell of a lot of harm to innocent people, or worse than that, your own blood. Are you hearing what
Yes,
I'm
sir.
saying to you?
Yes, sir.
All right. You will find that if you come back in here again, like this last case that you got revoked, basically, I'm not going to be looking at you with a very understanding eye.
Yes, sir.
You are warned, okay? I will look at the facts and the evidence, but don't put me in a position where I have to look at them again.
Yes, sir.
Good luck to you. Stay out of trouble, sir.
Thank you, Your Honor.
Thank you. Mr. Hunt, thank you for your help. Hello,
Judge, may I put him in a breakout room with,
Maricela Luna.
yes, sir.
You cannot leave right now. The lady that's right in front of you there, Maricela Luna, is what's called CLO. She will start you off on the probation. Probation is going to read to you all the conditions, not necessarily Ms. Luna, but probation will read to you all of the conditions. You will sign them, and they're going to put a copy in your hands. You will know exactly what you cannot do and exactly what you must do. Are you hearing me?
Yes, sir.
By the way, you are a U.S. citizen, right?
Yes, sir.
Okay. All right. Then that concludes this particular hearing at this time.
Thank you, Your Honor.
Judge
Thank you.
Longoria, this is
Hello.
Rosendo Parra.
Yes, sir.
My client has signed all the documents and they should all be on your side now.
Yep. And it is 12:21. We're going to have to come back after lunch and finish that up, sir.
Understand?